Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hardworking Americans and their families? You will. This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefit in benefit plan. Now prepare to learn, plan, save, and protect with the Phia Group.
All right. Well, good morning, ladies and gentlemen. We are live in studio. It's not usually the case, but as this is the holiday week, Boston and Kentucky, or Canton and Louisville, whatever you want to call it, have merged. Typically, we're running the hardware from headquarters, and Cindy Merrell, who's with us today, is usually with us via satellite, as they say. Is that even the appropriate term anymore, via satellite? That's probably outdated, but whatever, I'm old. But no, today she's here. She's sitting across the table from me, and she's going to be able to see the facial expressions on all of my musings. So,
Hello, everyone.
Cindy, how are we doing? How was your flight?
It was wonderful. It was quick. There's a direct flight right out of Louisville, straight over to Boston, and got in. And I got a good tour of the office this morning. It's absolutely gorgeous.
Were you not here last year?
I was, but I didn't get the full-on tour. And
Got it. They took you right into the training
we
room.
were still, yes,
You were not allowed out.
Well, we were still kind of a little post-COVID. So this is absolutely a beautiful office. There's lots of great big space, and I'm excited to be here.
Yeah, as you know, it's funny. I was talking about this with an employee yesterday, Katie Delaney, for anyone that knows her. We have windows now. And that wasn't the case. The old building, I was literally in a glorified closet, no windows. But there is a slight downside to the windows, and that is you experience the darkness coming. So usually what happened is I would come out of my office and then look across to the only offices that had windows and be like, oh my God, it's dark out. What do I do? Now, you witness it happening. It jacks your mind up a little bit. At least it does for me. I don't know. And Katie seemed to agree with that theory. So
I have to say,
it's
somebody who lives in Kentucky, it gets way darker, way quicker here. So I completely understand that. That's very dark.
And then the last thing I just want to say, I don't know if Cindy feels this way, but I was just a victim of a felony. Patrick, our esteemed producer, decided to record about a 10-minute conversation where I was saying offensive things as usual. So if it gets out, I will be calling the authorities. I don't necessarily mind saying offensive things. If I'm going to be on tape saying offensive things, I would like the opportunity to know that. So that's all I'm saying. Don't trust Patrick.
But we still love Patrick.
Well, get back to me on that next week after I've had some time to process the violation of my rights.
In law school, I think we learned a little terminology on that.
Expectation of privacy.
Yeah.
But look, in the state of Massachusetts, we're a dual consent state. So recording anyone without their consent is technically a felony. That's just saying. I'm not pressing charges right now. You better hope I have fun at the Christmas party, though. Anyway, I will stop with the stories. Thank you so much, everyone, for joining, listening. So we've got some fun stuff to talk about today. As fun as Subro can possibly be. I do my best to make it entertaining. Maybe people find it entertaining. Maybe people think I'm a jackwagon. Whatever. I don't really care. But today we're talking about something that, the prospect of it comes up a ton. And obviously when you folks talk to Cindy or I or some of the other lawyers working here with us, it's a concept that comes up every so often. Some plans can do it, some plans can't, as we know in the ERISA world. In most instances, it depends on what your language says and does your language allow for it. But there hasn't been a lot of case law on the issue. And really that's the issue of offsetting. Why is offsetting important concept for us? And we're going to talk a little bit about a case that had come out that does some important stuff for us. But certainly historically, what's important to remember is private plans that are governed by ERISA go through the same phenomenon. At some point in their subrogation journey, they get a phone call from me, Cindy, someone like me and Cindy, and we say to them, hey, I know you were told and believe that, ERISA gives you this incredible power to wield. That's true. But it comes at a cost, literally comes at a cost. And often certainly plans that have recently come over from the fully insured world have never had to deal with this. So Chris, I've never had a subrogation issue. What's going on? We constantly tell them, look, I know you paid $1 million. There's only $100,000 available. And unfortunately, most people in America do not have the assets to satisfy an award of your fees. By the way, in 18 years, I've had fees awarded once ever. And the lawyer was doing really, really, really offensive, crazy things. And so a lot of things have to go exactly right. And a lot of things have to be exactly true for you to even have a shot at getting your fees ordered. That's a conversation. In fact, that might be a good thing to talk about at the next podcast. But anyway, more often than not, plans are looking at a situation where You have rights to 100% under ERISA. Your plan language does exactly what it needs to do. It has language that says we're entitled to our fees if you make us sue you. And I'm sitting here saying to plans, hey, look, sorry, but if you want all your money, you're going to need to sue. It's going to cost you 50 grand. And by the time all said and done, you're actually worse off than you started. We should probably settle this case. Offset is an interesting tool that more often than not, I like to say it's what's the saying? It's better to have a gun and not need it than need it and not have it. Offset, a little like subrogation, is like that. I don't necessarily want to have to do it, but I like to have the ability to threaten it. And so, Cindy, why don't you kind of tell us? Offset should be somewhat obvious what it is, but for anyone that maybe has no idea what subrogation is but is listening anyway, let's tell them what offset is.
So when we talk about offset, what we're talking about is a health plan will likely be aware on some level that their member was involved in typically a motor vehicle wreck. This is normally when we come across offset. And for whatever reason, the plan has determined that they are going to deny claims because of this third party liability. And then what happens is we let the plan know, hey, we have these benefits. We have all of the information you need to go ahead and process the claims. And once they review those claims, they're aware now that they've paid those claims. They're aware that the member is involved in typically a motor vehicle wreck, and they go ahead and pay the claims knowing that the member has a third party liability claim outstanding. And while we're tracking those files, sometimes we have attorneys that will not cooperate. Even though they'll cooperate with us for a little while, time of settlement, they get a check and then they send the money. And so then we're looking to the plan language to see if it contains offset. Offset is when the plan can say, we paid $1 million. We are going to offset your future benefits. You're up to $1 million because that's what we paid.
Regardless of whether they're denied to the accident, that's an important
Correct.
thing.
Yes, they don't ever have to initially be denied. I bring that up only because the plans are typically aware of this third party claim and they want updates as far as what kind of limits are outstanding. Once the plan elects to offset benefits, their benefits will be processed and denied up to the next $1 million because the plan is attempting to offset the member's future benefits. I am aware of a large self-funded ERISA health plan that has, in fact, denied not just it was a dependent adult child made a claim and she went ahead, settled the case, took the money and ran, and the plan offset all family members' benefits because their plan language allowed them to do that. So let's talk a little bit more about the specifics of case out here that we want to talk about with you today. It's called Mull versus Motion Picture Industry Health Plan. Go ahead, Chris.
Yeah, so Mull, we'll just call it Mull from now on. It's really important to understand about this case. We'll get into some of the details here in a second. But it came out of the Ninth Circuit. Why is that important? The Ninth Circuit, I would say, has historically been one of the most aggressive circuits against us. Most of the states in the Ninth Circuit, you are allowed to recover. You do have Arizona, which gives you basically, there's some exceptions for municipal plans, but for all intents and purposes, an anti-subrogation state. California is anti-subrogation, but allows reimbursement. But remember, there's like 9 states in the Ninth Circuit. So generally speaking, all of them, I wouldn't call them anti-subrogation states in the traditional sense. They are all anti-subrogation states in the sense that there is case law in all of them that impacts your rights, made whole rules, common fund rules, all that fun stuff. Those would not generally be considered anti-subrogation states. But as I like to say, if I'm going to walk into a courtroom and have a judge less than thrilled that we're fighting over this because he thinks the made whole rule applies, for all intents and purposes, you have an anti-subrogation vibe in that state, as I like to call it. So the Ninth Circuit, for all intents and purposes, is made up of a lot of states, a lot of jurisdictions that have animus towards insurance plans. Let's call us insurance plans, even though we're not all insurance. That is the benefit we're providing, right? They have animus towards us, and the Ninth Circuit, specifically at the federal level, has in the past done some pretty aggressive things. The most aggressive of them being CGI v. Rose. A lot of people don't know about this case. CGI v. Rose was coming up at the same time as U.S. Airways versus McCutcheon. U.S. Airways versus McCutcheon, we know, went to the Supreme Court, effectively clarified Sereboff, and applied sort of the general concept of you can recover to, by the way, equitable doctrine that would limit also are not applicable if the language is good enough. Plaintiff's lawyers would tell you that's not what the case says, but it is what the case says, even though the plan lost. But see, most people don't know about that because there were 2 cases being considered to go to Supreme Court. It was U.S. Airways, McCutcheon, and CGI v. Rose. I actually think CGI was better for us. So I don't remember the exact circumstances, but I do remember this. The plan was only demanding 10% of what the settlement was. So when you look at that, that fact right there makes it really compelling. and the plan had good language. What did the court do in CGI v. Rose? They used principles of contract for reformation and rewrote the terms of the plan for that case. That's what the Ninth Circuit did in 2013 or whenever McCutcheon came out, because it's about the same time as going on. So when I tell you they've been pretty aggressively anti-subrogation, I think that's one of the best examples. And a lot of people don't know about that case because it didn't hit the Supreme Court. Nobody knows about it unless you were following what was going on in the courts at that time. So it's really important to understand who we're dealing with here. Well, Mull is one of the biggest decisions ever to come out to basically support this concept of offset. The court basically said, you're okay to offset. Now, the case would imply that there are limitations to that, right? Cindy brought up sort of this concept of how much can you offset the whole amount of the settlement versus all of the benefits, yada, 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 right? And plans will sometimes think, well, they had $100,000 available, so we're going to offset the whole $100,000. In theory, you could do that. But if you tried to say, well, we paid $1 million and there was only 100,000, we're going to offset the next $1 million in claims that come through. First, you have the problem that we're a much more mobile workforce than we've ever been. And so the risk that that participant doesn't stay with you long enough, and certainly in the Mull case, that was a problem because you said it was a dependent.
The Mull case was not a dependent, but it was another case I'm aware of that
it was an adult dependent,
yeah,
right? So imagine you've got a 25-year-old whose benefits will cease as long as they're out of college, or even if they're in the college by the time they're 26. I think it's 26 regardless. So you got a 25-year-old who has a really bad accident. You think you're going to get another $1 million out of them in the year between 25 and 26? Probably not, right? So you've got that problem, the risk that you may never get the chance to offset X amount of dollars. But certainly this concept of, well, we paid $1 million, we're going to offset $1 million, even though there's only 100,000 available. I've historically said I think there's some fiduciary concerns there. And so I think plans need to be very conscious that that type of punitive action in the context of that, I think if plan had a really, really, really good provision that talked about termination of benefits if there's non-compliance with the terms. I think in that case, maybe there's more because you're not being arbitrary. You're not saying, well, you had $1 million, the other guy had 200. And so there's a little bit of an arbitrary nature to that. Whether a court would find it arbitrary, capricious, I'm not sure. But there's a lot of variability there. If your policy is if you do not comply, we terminate your benefits, you have really good language in that regard. I think that kind of punitive measures are different. But more often than not, I've rarely, if ever, seen a plan terminate benefits because of a separate situation. But the conversation we do have a lot is, well, I'm not paying it. We're denying up to all action-related claims, even though that wasn't available. And that's a compelling one because it happens a lot, like in almost every case where the plan paid a lot of money. There's not going to be enough money to cover that. It's very, very rare. I just had a unicorn this week, but literally it was a unicorn. 700,000 paid, 5.2 million.
Oh, wow.
Settlement.
That's a great one. Yeah.
Unicorn. That doesn't happen. It was one of the only times I went to the client and I said, I don't typically feel confident telling a plan they could sue and win because the money just doesn't make sense. But I think you could sue, you could win, and you'd still make out way better off. So that's very rare. Usually I'm like, plan, would you win? Yeah, does it make sense? Probably not. So anyway, plans absolutely have to be conscious of that. And Mull doesn't go into that heavily, but it does sort of dance around this issue of having a limitation. Certainly you could interpret a limitation that comes out of it that you can offset up to the amount that was available and no more. A really important fact about Mull that I think most people would maybe gloss over if they were talking about it. Cindy, when did that case start?
Oh, it was all the way back
injunction filed?
2013.
The litigation process on this thing started in 2013. Now let's give it a 2-year COVID credit, okay? So 2022, what's that, 9 years? Let's say it was 7 years. In normal times, let's say COVID doesn't slow the thing down. 7 years. Anyone that has been paying attention to inflation knows that money 7 years ago was worth a lot more than it is today. And so there's that whole sort of financial part of it where plans do need to be conscious. When I say to you, have fun seeing your money in 3 to 7 years, right? Depending. That's a consideration I think plans also need to think about. And there's another really important part of this case here. And that is the procedural sort of posture that it took and how it kind of got there. Because that was another key aspect of how the decision came out. So did you want to go into that at all?
Sure. So while we're talking about the procedure part of it, it does matter in the court's opinion. So initially, the Mulls are the ones who filed an injunctive relief, asking the court to declare essentially the plan's rights. What are they entitled to? So the Mulls filed first the injunction. Then the plan answered and filed what's called a 502A3 claim, which is constructive trust claim. That's essentially the plan asking the court to say, there's this identifiable fund and we have a right to that fund. And then essentially there was some bankruptcy, it bounced around, and then ultimately it's gone through the Court of Appeals, it's gone back to the trial court, it kept going around. And then ultimately here we are, the Ninth Circuit in 2022. I believe this decision came out over the summer. I don't know exactly which date, but it just came out here in 2022.
Yeah, so obviously the time frame, but the important part here is one of the key tenets of the court's opinion was the fact that the plan was being defensive as opposed to offensive mattered. And it sounds like there was a bankruptcy proceeding, so presumably, and I don't remember the exact details here, but presumably there was an issue of availability of the funds. And what do I mean by that? We know that under sort of traditional ERISA rules, plans are only entitled to, I like to say, the money, not any money. You're not entitled to any money, you're entitled to the money. And that might sound really weird and not make any sense, but if you think about the simplicity of what I'm trying to say, the money I have in my bank account today is any money, is all the money I have, any money, any assets, whatever. Everything I've purchased up to this day is any money, okay? You, the plan, would not be entitled to any of the money I have today under any circumstances. The minute I get a settlement and I have $100,000 in my hands, now I have the money, right? I just talked about all money I have as any money. Now I get a new check today, a settlement from an accident. I have the money. You are entitled to the money, that money. Imagine that money was in a briefcase with a special lock on it and only one code existed, okay? If you couldn't open that box, you wouldn't be able to have the money. Like the money just wouldn't be available to you. And so the point is, if somebody spends the money on a non-traceable asset, it's gone. Well, here in a bankruptcy issue, and the bankruptcy issue gets interesting because theory, the money should not even be part of the bankruptcy estate because it's being held in a trust, sort of a constructive trust, which is not a real trust. But again, we could do a whole podcast on that whole construct. So in the bankruptcy issue, technically the settlement money never became yours. Accordingly, it was never part of your assets. There's all this fight over whether the bankruptcy estate even has the jurisdiction to dispel or decide on that money. But the fact that they filed for bankruptcy implies maybe they don't even have the money anymore. And if they don't have the money, it doesn't matter whether the bankruptcy court has jurisdiction over it or not. You're not going to be able to get it under 502A3. And so the fact that the court allowed the plan to effectively come outside of the 502A3 paradigm, structure, whatever terminology you want to utilize, and use what they called extrajudicial remedy self-help. The court effectively allowed and established that an extrajudicial remedy, so outside of a lawsuit, outside of 502A3, is allowed. It's as if the offset piece, even though it's part of a subrogation system, it's part of the plan language, literally more often than not, it's in your subrogation language. The court effectively said, we're going to call that a sidecar that is outside of this 502A3 regime. And since 502A3 has said you need to be able to access the money, but this is outside of 502A3, we're going to let you do it. And so it was really interesting to see how the court, the Ninth Circuit especially, came down on this issue. If you had told me the Ninth Circuit was going to rule on this before, actually, I did know. We've been talking about this case at the conferences for years. I didn't feel good about the case knowing that it was in the Ninth Circuit's hands. And so it's always really interesting to see how courts come to whatever decision they come to, what legal gymnastics they go through to get there. And so the concept of an offset today is a much stronger strategy than it probably has ever been, because we now have, one of the most influential courts in the country, the largest court in terms of jurisdictions, coming out and sort of setting a bit of a precedent, a baseline, whatever you want. That doesn't mean every federal circuit's going to say the same thing, but more often than not, if more circuits start to come out on this issue, these kinds of decisions will potentially persuade others. There's another important piece that folks need to understand. If you even have the capacity to administer this, right, because it can be complicated and expensive to administer, let's assume that's not a problem for you or your TPA. Understand that it's going to open you up to additional liability through a very easy mechanism, meaning the appeals process. Every single claim you deny after this is going to open up the appeals process. It's going to have to go out on an EOB as an adverse benefits termination, which kicks off your appeals process. And because in more often than not, these cases already have lawyers attached to them, you're likely to see both of the appeals, not all of the appeals, not just the first level appeal, right? We always say the first level appeal is sort of a throwaway appeal because it's the second one that controls, right? The final appeal is what controls, well, at least procedurally speaking, and then they can appeal. But the fact of the matter is, even if you were to appeal through the first two, more likely than not, either by way of an IRO or not if you're outside of that process for grandfathering or whatever the case may be. That stuff's a little bit outside of my normal realm. You're looking at an appeal process, and probably one that goes all the way to an IRO or a court or whatever the case may be. So just be mindful of that piece of it. Again, more often than not, there are lawyers. You're more likely to see it. Now, as I like to tell anyone that will listen, approximately 80% of cases are worth $20,000 or less. Are you all of a sudden, if you start offsetting, going to see tons of appeals? Maybe not. If you're offsetting on a $5,000 cases, any lawyer really going to want to go through that? It's too expensive, yada, yada, yada. But just be mindful that there is a much cleaner road to fighting your adverse benefit determination on the back end than there would normally be, because normally the problem is the lawyers are saying, here's your money, come get it if you want. It's just going to sit in my trust account. And that's if they're giving you that much consideration, not saying, go pound sand, I'm dispersing the funds. Go ahead and try to stop me, right? They're literally going back to sort of the beginning of this conversation where we call you guys and we say, hey, look, yeah, your rights are great, and we actually think you're going to win, but it's going to cost you a ton of money. Most lawyers understand that, and they're calling our bluff. You're not going to do anything about it because it's 10 grand, it's 20 grand, it's going to cost you way too much. And I know you're not going to do anything about it. So go ahead. What's your play? And it's really important to understand all the dynamics of this and how it all plays out, or how it could play out, and understand that even though this option is available to you, as I said before, more often than not, it's like a gun. Better to have it, not need it, and need it, not have it. And that's coming from a Northeastern Yankee, right? Regardless of my opinion about guns, if I was in a situation where I thought I might need one in that moment, I'd be like, man, I wish I had a gun right now, right? But, as administrators, as plans with fiduciary obligations to both, that plan participant and all plan participants and viability of the plan, all that fun stuff, it's important to understand this option is available to you. More often than not, I like it better as a threat than an execution, because, to the point, on a $7,000 case, if a lawyer's like, my client doesn't have the money to pay me to go sue, run through an appeal plus the lawsuit that will happen after the IRO comes our way or whatever, if the risk is there, then they're more likely to be like, all right, look, I'm not going to pay you $7, but why don't we do $5 or $4 or whatever? And so that's the game of negotiation. That's more often than not why you guys are calling us, right? So we can manage all of the legal stuff that's happening and understanding of what's happening legally, and then applying that to a more practical approach of how do you actually get from, we have these great rights, to money in my bank account. Do you have anything to add?
My takeaway from this is this has given us just yet another tool in our toolbox.
100%.
And I've always brought it up in situations that we're talking about. However, now I can go and I have a clear path to showing them this is real, this is legitimate, and plans will do this. So I am very excited about this case, and I think this is going to be helpful for us in the future.
Yeah, I definitely agree. Anyone that is not sure if they have offset language in their plan, you should probably be calling us right now, because if you don't have offset language, newsflash, if you haven't already figured this out, you should. And if you happen to not have offset language, would you be surprised to know we can help you get some? Not me specifically. I'd have to phone some friends over in our Phia Group Consulting division. But certainly if you're listening to this going, man, I wonder if we could do this, the answer is maybe, as any good lawyer will answer on anything. It depends. So please call us if you have questions about subro. If you're not sure if you have the capacity in your plan language to pull this off, then to kind of talk strategically. Certainly, if you have a case sitting on my desk right now, you might be getting a call about it anyway. But, as we're dealing right now, end of year, plan renewals, whatever, it might be too late if you're really up against the plan year to call us and get something put in here via an amendment. But obviously you can amend anytime. So when you go home for your Christmas breaks, make sure to bring a copy of Plan Doc with you and review it over dinner, as I will probably be reviewing something over dinner. That's all I got. Merry Christmas. Happy holidays. Enjoy all of your holiday soirees or whatever. Cindy and I are probably taking the rest of the week off because why not? It's Christmas. I'm totally joking. That's all I got. Thank you so much, everyone.
Thank you, everyone.
On behalf of Cindy, myself, the Phia Group, and the entire subrogation community, have a fantastic holiday. Enjoy your families, and we will see you next year here with the CNC Subrogation Factory. Thanks, everybody. Bye-bye.